Good evening, everyone. What a joy it is to see you all in this room. So much energy. I mean, you feel it, right? It's pretty great. Okay, so it falls on me to welcome you, which I am definitely here to welcome you. I'm so excited that you are all here. So as you know, this is the final round of the Sherman Minton Moot Court competition. And I am really glad that you are all able to join us here in person. There's also an audience online who I'm also very grateful is watching, and I'm glad you are with us here tonight as well. So for those of you who don't know, this competition is named for Sherman Minton. He was a 1915 graduate of the law school. Sherman Minton finished first in his law school class while simultaneously playing for the IU football team. Minton became a U.S. Senator in 1935 and was appointed to the U.S. Court of Appeals for the Seventh Circuit in 1941. President Harry Truman nominated him to the U.S. Supreme Court, where Minton served as an associate justice from 1949 until 1956. He set the benchmark for Indiana law graduates on the judiciary. Our alumni have gone on to blaze trails at nearly every level since then, including Linda Chesham, the first woman to serve on as a county judge in Indiana, Sue Shields, the first woman to ever serve on the Indiana Court of Appeals, Loretta Rush, the first Chief Justice of the Indiana Supreme Court, and Juanita Kidd Stout, the first African-American woman to serve on a state Supreme Court anywhere. All four of them are right behind me. And just earlier this month, Derek Moulter was sworn in as the newest member of the Indiana Supreme Court, making him the fourth of 5 Indiana Supreme Court judges that are currently sitting. So we are incredibly proud to have 4 of the 5 be Mauer alums. The competition that we are about to see is the largest and all of you who have participated in it make up the largest co-curricular and alumni event of the year. Participants can be proud of the very, very hard work that they've put into this competition this entire fall semester and even before that. If you do a Google search about the competition, you will find that, in fact, many of our alums continue to list their participation in the Sherman Minton Moot Court competition for their entire careers. It forms such an important part of their identity as lawyers, whether coming through the law school. In fact, one of tonight's judges, Judge Damon Leichty, he earned his JD from our law school in 1999 and is a former winner of this competition and now serves as the U.S. District Court for the Northern District of Indiana. So we are incredibly grateful to have him with us, as well as Judge Sara Ellis and Judge Thomas Kirsch. So this fall, 97 of our 2Ls competed, with 64 advancing to argue at the Court of Appeals level. Congratulations to all of you. And more than 115 alumni and friends volunteered their time to serve as judges. So I want to thank all of them, some of whom are watching online right now, I know, for all of their effort and their extreme dedication to the law school and their time and their wisdom. We really couldn't have this competition without them, and we're incredibly grateful for all that they give to the law school. Finally, I'd like to recognize the tremendous amount of work from the Sherman Minton Moot Court Advocacy Board, whose truly tireless efforts have made tonight's event possible. So thank you, all of you. Can we all just give them a round of applause? I'm sure we're going to do that. Now it's my honor and pleasure to get to introduce to you Professor Lane McFadden. Many of you know him well already, but let me just tell you, for those of you who don't know him, a little bit about him, because I'm sure he does not actually tell you the ways that he is amazing, and he is amazing. He is an experienced appellate and environmental attorney with over 16 years of experience as a practitioner for the federal government. He clerked for Judge Andrew J. Kleinfeld for the Ninth Circuit Court of Appeals in Fairbanks, Alaska, and then for Judge Lawrence Smith on the United States Court of Federal Claims in Washington, D.C. In 2004, he joined the United States Department of Justice as an appellate attorney in the Environmental and Natural Resources Division, where he served as lead counsel for the United States in dozens of matters and presented more than 40 oral arguments to federal courts of appeals around the country. So when he is teaching you, he knows of what he speaks. After several years serving as senior counsel to the Federal Aviation Administration, Professor McFadden joined the law school here in 2021, and we are very, very grateful for his time, energy, and dedication. He teaches legal research and writing as well as appellate advocacy, and he does all of this. Advocacy is in his DNA. As a student at New York University School of Law, he won first place in the Orson S. Martin Appellate Advocacy Competition. So without more, Professor McFadden.
Thank you, Dean Ochoa. After all that wind-up, I'm going to embarrass myself in front of my appellate advocacy students by using notes, but just do as I say and not as I do. It is really exciting to see this turnout here. I think it's really fitting for an event that Dean McFadden described this afternoon as the Super Bowl of Law, the Super Bowl of Law School. And certainly for our four competitors tonight, it is that. But for the rest of us, I think of this as a celebration of our broader law school community. Despite Dean Ochoa's suggestion that I was somehow responsible for all of this, that is 100% not true. This is a massive undertaking by a huge number of people. And I just want to emphasize what the scale of that undertaking is. We had students from all three classes, members of our faculty, members of our administration, recent graduates of our law school and not so recent graduates of our law school, members of the bar who aren't graduates of our law school, members of the judiciary, all devoting an enormous amount of time and effort to make this event what it is. First, I want to start by acknowledging the students in the spotlight, the 2L students that signed up voluntarily to undertake a difficult and time-consuming enterprise during the most difficult semester of law school, all just so they could learn something. I mean, I think that's truly remarkable, and I want to recognize that. Dean Ochoa says, you know, this is the largest sort of co-curricular event with our alumni, and it is also one of the larger internal moot court competitions amongst any of our peer institutions. I think that's truly remarkable, and I think it speaks very highly of the intellectual curiosity and the drive and the interest in refining and developing skills that our students have, and I don't want that to go unacknowledged. Those students all then wrote probably their first appellate brief, right? All during their free time in September when they were otherwise totally idle. Then they came back from fall break. They delivered a total, at my count, 320 separate oral arguments in 160 rounds. All of that's before tonight, right? And in the rooms with them during all those rounds are almost 41 L students who also volunteered to come to campus at night, dressed up, signing up to sit in the rooms and watch something that they probably didn't have any idea what they were signing up for, all because they too wanted to learn something, right? And would take advantage of the opportunities that the law school gave them. And I also want to recognize the 3L class who formed the moot court board, who deserves the applause they got. They worked tirelessly for months to ensure that this was a competition of the caliber that a school like Maurer deserves. In a minute, the Chief Justice of the Moot Court Board is going to get up and acknowledge a lot of people by name, which I think is very deserving. So I'm not going to do that, but I do want to emphasize again just the scope of the amount of student work that goes into creating a competition like this. The students wrote this problem. They wrote all the trial exhibits and judicial opinions and bench memorandum that come with it. The students were the ones who reached out to our faculty and out to our alumni network to ensure that every time a competitor showed up, they were judged by members of the bar carefully and conscientiously, and that they got valuable feedback, and that they were heard, and that the competition was fair and well run. It was the students who managed the incredible logistics of a 5-week competition where people are coming to campus multiple nights a week and they need parking passes and sandwiches and directions, and someone's got to be here early and someone's got to be here late, and the students did all of that work. The students graded all 50 appellate briefs that were submitted, and they took the time to make sure that each brief was carefully read by multiple people to ensure the grading process was thorough and fair. I calculate about 400 hours of volunteer time by 3L students just to grade those appellate briefs. And they helped judge 188 separate practice oral arguments on a totally different problem before this competition even began, just to make sure that when the competition did begin, it would be as high quality as it possibly could, and that the 2Ls felt capable and confident before they walked into their first round. I just want to take a moment to recognize the almost 175 students of the current student body from the first year, second year, and 3L classes who made the Sherman Minton competition what it is. Can we please get a round of applause for those students? But those students weren't alone. As Dean Ochoa noted, we had almost 120 members of our broader law school community come in to judge at least one round of the Sherman Minton competition. A lot of those are our most of those are our alumni, and a lot of them come back year after year because they recognize the value of this competition, not just for the current student body, but for the profession into which the students are about to graduate and where they're going to join. I also want to recognize Dean Ann McFadden, who worked behind the scenes to acquire a lot of those judges, often at the very last minute, to ensure that our rooms were full of very capable and conscientious people. And so I don't want her to go unacknowledged. Tonight, we're going to crown two champions of the 2022 Sherman Minton Moot Court competition, and they will very rightly be proud of all of their accomplishments. But I think that everyone here, whether you're a competitor or a bailiff or a moot court board member or a faculty member, or you judged around, or you're a graduate of the law school, or you're a classmate of the people who are involved, or you're a friend of the people who are involved, or a family member, I think each of you ought to feel proud to be associated with this exceptional student body at this exceptional law school. I know that I am. And before I sit down, and Lord knows I will keep a microphone far longer than I ought to, I want to recognize one last person who is here in the room tonight, I am delighted to see, and that is Professor Seth Lawn. Professor Lawn is retiring at the end of this year, and for many years, he was the faculty advisor for this competition. This was my first year of being involved with it at all. And when I came in, this competition was already a hugely important part of the culture of this law school and one of the highlights of the entire academic lens. So Professor Lawn, I want to say thank you to you, and I want to make sure that people recognize you. And now I get to introduce the Chief Justice of the 2022-2023 Sherman Minton Executive Moot Court Board. Zach Lewis is, of course, an accomplished law student with an impressive resume, but more importantly, he spent this semester answering my random questions at all times of day and night about all kinds of things that I didn't know or didn't understand. Every time that I interacted with Zach, I was very impressed by the thoughtfulness and conscientiousness that he brought to this competition. And that goes to all of my interactions with all of the members of the Moot Court Board this year. They really deeply care about this competition, and it really showed with the care they took in their efforts. So it is my great pleasure to introduce now Zach Lewis.
All right, thank you for the very warm welcome, Professor McFadden. As he said, I really want to call out some members of my board that have just been incredible this year. I've been very lucky to lead this board. It has not been hard to lead this board. They've just been incredible overall. So first of all, I want to recognize our problem coordinators, Kaylee Perrine, Ellis Artema, Alex Myers. You guys created an amazing problem this year. All the judges have commented on how interesting, relevant, and just overall well put together. Even in talking with these judges, they cannot find fault in your guys' work, and that's very, very impressive. And our competitors can say the same about that. It was not easy, in a good way. So our judge coordinators, Brendan Gooden and Ben Bailey, you guys secured hundreds of judges, sent hundreds and hundreds of emails, didn't receive responses to many of them, and dealt with that, you know? You kept going, you got great judges, and all the way through, I'm just very proud of you guys. Our competition board coordinator, Michael Gilger, he led our 1L bailiff boards and our 3L comp boards. So those two boards are integral to our success as a board. We need our 1L bailiffs like Serena, and we need our 3L comp board members to grade all the briefs, to judge all these arguments. We could not do this without those boards. And Michael was in charge of all that. He coordinated all that to make sure everyone showed up every time. Our executive advocacy coordinator, Ray Derberry. You'll see more of Ray leading the trial and the ADR competitions in the spring, which I recommend you guys all do. So he has been helping with this competition as well, though. He was always around, always available to help us with anything we needed. And then Ray will be your man for the spring, so look out for that. Finally, our ECCs, our executive competition coordinators, Mariah Davis, Courtney Davis, and Alex Esposito. Mariah, on the logistics side, I never had to ask you about anything. If I asked you, it was taken care of, so I stopped asking. Anyways, and Courtney, I mean, you redid the whole scoring system this year. It's going to benefit our competition for many, many years to come. The next person in your shoes will have it made way easier than you did, and that's been amazing for you. And we also appreciate the help of Professor Stake on that. And finally, Alex, you did everything social media, everything communications, everything emails, and we really appreciate that. So thank you all. I mean, it's been a joy to work with all of you, and yeah, I'm sad to see the competition end. I'm also proud of the work that we've done, so it's a mixed bag right now. Furthermore, I want to thank Professor Lane McFadden. He gave us a lot of credit, but a lot of credit is due to him as well. We could not have done it without the knowledge and support of him. And as he said, this is his first year, so you guys are in great hands. As much passion as we have for this competition, he has more somehow. And I can tell you guys are in great hands, especially U1Ls next year. You'll have a great experience with advocacy, and U2Ls too. Take advantage of everything that he's going to offer you next year. Finally, we're incredibly thankful to Dean Ochoa, Dean McFadden, Katie Beck, and Chelsea Browning. From the administration, we've had everything we could ever ask for. If we asked for something, we'd had it. If we needed support on something, if we need mentorship, if we needed help dealing with a difficult situation, we had support. So we really appreciate that. Professor McFadden kind of took my thunder on this part, but we started with 11 members, or 100 members of the 2L class, and it began in September when the problem was released. So these competitors wrote appellate briefs in teams of 2, so 50 briefs were turned in, and then they advanced to many, many oral argument rounds, each time getting a score that would slowly narrow down the pool half each time. So we're now down to our final 4 competitors. You guys have compressed us round after round, and I'm excited to see what you guys do tonight with this panel of judges. Before we begin this final round, we would like to honor our top 32. These competitors excelled in brief writing and oral argument skills. To be in the top 32 out of 100 is very impressive. That's even less than the top third. At this time, I would like you guys to stand. And please join me in a round of applause for these competitors. Congratulations, guys. Thank you for your hard work. We're very impressed. So now I just want to briefly introduce the facts of this problem so you guys all know about it. There's more information in the pamphlet, but briefly, this problem was set in Arcadia City in the district of the 14th district, which is obviously a mythical district. It follows the howling hijinks of Bethany Gates and her heist to steal the Bill of Rights. Her subsequent arrest raises 2 major legal questions that are currently split in circuits across this country. Detective Jenkins' search of Bethany Gates' laptop raised the issue of to what extent the private search doctrine extends and what reasonable expectations of privacy under the Fourth Amendment are. In moving the museum curator from one room to another in commission of her crime, the definition of different location under the federal sentencing guidelines abduction enhancement was raised. This year's problem asked students to explore how the law both defines and expands boundaries. For one issue, competitors grappled with how society's privacy expectations in an increasingly digital age are changing. The other issue tasked competitors to define the physical boundaries of a crime scene. The competitors will argue these issues before our esteemed panel of judges here. You can find their biographies in the pamphlet. We are very blessed to have them here today. And our first 2 competitors will argue the issue of reasonable expectations of privacy in the digital age under the Fourth Amendment. Finally, our next 2 competitors will argue over the definition of different location under the abduction enhancement of the federal sentencing guidelines. And as I said, a more extensive fact pattern can be found in your pamphlet. After the competitors argue, the judges will deliberate and choose the best 2 oralists regardless of the side or issue. And while these justices deliberate, there will be refreshments in the lobby. We'll take a break. It'll be about 30 minutes. So finally, without further ado, we're going to convene the court. Thank you all, and I hope you enjoy.
All rise. Oyez, oyez. We are here in the matter of Bethany Gates versus United States of America. Counsel for petitioner, you will have 15 minutes to argue. I will reserve 2 minutes for rebuttal and set your timer accordingly. Counsel, you may now proceed with your argument.
Good afternoon, everyone. On behalf of the court, congratulations to the finalists. The court will now hear the case of Bethany Gates versus United States of America, number 22-1392. And Mr. Miller, you can proceed whenever you're ready.
Good evening, Your Honors, and may it please the court. My name is Zion Miller, and I represent the petitioner in this case, Ms. Bethany Gates. The private search doctrine boils down to one fundamental principle. It allows for verification, not investigation. We're here today because the government disregarded that principle when Detective Jenkins opened a folder on Ms. Gates's laptop that had not been opened by the private searcher. As a result, he violated Ms. Gates' Fourth Amendment rights. And we ask that this court reverse the 14th Circuit's holding and grant Ms. Gates' motion for a new trial and to suppress evidence. The 14th Circuit erred in two distinct ways. First, the court incorrectly held that the scope of the private search included the properties information of the Halloween hijinks folder. Second, the court incorrectly held that police officers are allowed to exceed the scope of the private search so long as they are substantially certain of what they will find. Beginning with the first issue, the scope of the private search, the Supreme Court case United States versus Jacobson makes clear that the scope of the government search must be limited to the scope of the private search, the information that the private searcher themselves viewed. And that's problematic.
Mr. Miller, can I ask you a question? What concerns me about this is line drawing, okay? And where do we draw the line? So, you argue that the police officer went into a different subfolder contained within the folder, right? I understand that. But if the police officer would have looked at a different photo in the subfolder, okay, you would be arguing that the police officer should have only looked at the photo within the subfolder. That would be your argument. But where do we draw the line as to what the police officer can look at under the private search doctrine?
The specific line we draw, Your Honor, is the specific exact information that the private searcher themselves looked at. So if taking the file example, it would be whatever individual files or whatever information they were able to visibly see. In this case, we don't.
Isn't that too narrow? Because we held in the cocaine container search case that the officer could look at the other packages as long as the officer was substantially certain that he was going to find drugs. And if we adopt your version of the line of the test, then the substantially certain prong is irrelevant. Because what you're saying is that the police officer can look at only what, in this case, Miss Gates' boyfriend looked at.
Your Honor, by the cocaine case, are you referring to United States versus Jacobson?
Yes.
Specifically with the cocaine test in Jacobson, the cocaine test itself was actually not a private search doctrine test itself. The court did conclude that testing the cocaine went outside the scope of the private search doctrine, outside the scope of the private search. But the court there actually employed a CATS analysis to determine that separate search was appropriate. It wasn't that they had virtual or substantial certainty as a part of the private search doctrine. It was rather that society was not prepared to recognize an interest in specifically whether or not this mysterious powder was cocaine or not as reasonable. And so under our conception of the private search doctrine, as consistent with Jacobson, the certainty aspect of this case falls into how certain the police officer is that they are accurately replicating the private searcher's actions, because in most of the cases, what we see is the police are the ones actually controlling the laptop or the cell phone in these private search cases when the private searcher brings it. If you look at, for example, United States versus Lichtenberger out of the Sixth Circuit, you see that the private searcher brought the laptop and the police directed the private searcher's actions throughout that in terms of following up on the search. And the court noted that because the private searcher wasn't certain of what folders she had looked at before, and because the police officer had directed her to look at other folders, there was no virtual certainty. But you compare that and contrast it with the First Circuit's case, United States versus Riviera Morales. In that case, the private searcher was in full control of the cell phone in that case when showing the information to the police. And because of that, the First Circuit found that there was no risk of going outside what had been previously viewed. The private searcher was capable of making sure that they followed the same file pattern. They had no incentive.
So Mr. Miller, and I'm sorry to interrupt you, but following that line of reasoning, suppose that the particular individual here handed 2 physical files to the law enforcement officer, both of which contained photographs, only had looked at the photographs in the one folder. Should we really expect law enforcement not to look at the photographs handed to the officer in the second folder?
Yes, Your Honor, we should expect police officers not to look at the photos in that second folder without a warrant. That's because the private search doctrine is fundamentally premised, as explained in Jacobson, on the idea that the Fourth Amendment only protects a privacy interest. And thus, once a third party has looked at this information, or in your case, this photo, that privacy interest is extinguished. The Fourth Amendment doesn't touch it. But if the private searcher has not looked at this information, that privacy interest cannot have been extinguished. And so if we say the 2 folders in this case, if they've been physical folders handed to the police officers, the police, in this case, Detective Jenkins, would have had probable cause to get a warrant in this case. He would have been limited to just look at that first folder at the beginning, but from that folder had enough information to get in contact with a judge, a neutral principled arbiter, and who's able to call these decisions more accurately, more fairly than somebody engaged in the competitive enterprise of ferreting out crime as concerned the court in Riley versus California. So yes, we do expect that police officers will limit their search under the private search doctrine, understanding that there are many other exceptions or exigencies that can present in Fourth Amendment issues, as that's what's consistent with the private search doctrine.
But go ahead.
Oh, I was just going to say, so Mr. Miller, what concerns me here is how the officer got to this folder, the hijinks folder in the first place, which was looking and running the properties function to see when these folders were actually created. And so is it your position that that itself, running the properties function, is a search of the laptop that goes outside of the private search exception?
Yes, Your Honor, that is our position. Again, the fundamental principle is that if a private searcher has viewed information, it's no longer private. This properties function was never run by Albert Chase. That information was still private. A good analogy of this comes from Arizona v. Hicks. In Arizona v. Hicks, of course, the police officers entered this apartment and then proceeded to turn around a stereo system in order to look at the serial number. The court held that the initial entering of the apartment was appropriate under the exigent circumstances. Just looking at the stereo system itself without touching it was fine. But as soon as they moved it to look at that serial number, that was a second separate search. That was not a part of the first one. And that's what we see here. This was a physical action, not a physical action, obviously it's being digital, but this was an additional action taken by the officers. It wasn't that the properties information was viewable upon opening this holiday photos folder. There had to be separate action taken by the officers, action that was not taken by Albert Chase. And thus that does exceed the scope of the private search doctrine.
Do you know what files or what photos Mr. Chase looked at within the subfolder?
Within the Halloween event folder, Your Honor, the trial record indicates that there were thumbnails visible within that folder. So the photos themselves were all visible upon opening that folder. If this were a case where all you could see was a file name, that would be different, but that's not what we're presented with here.
What can we tell police officers in the event of a file name? Can the police officers click on the file name if Mr. Chase had not?
No, Your Honor, they cannot.
Why not?
That's because the private searcher has not viewed that information. Ultimately, Jacobson made clear the purpose of the private search doctrine is just to confirm private searcher's recollections.
But isn't it coextensive within the scope of the antecedent private search?
No, Your Honor, under our interpretation, the scope of the private search is strictly limited to whatever the information the private search reviewed.
Then what does coextensive mean?
Coextensive means mirroring in our interpretation of this. For example, if you look at Jacobson, when they went through that package, the private searchers had thoroughly ransacked that package. They had seen everything that was in it.
Then why is there a second prong to the test? I mean, maybe your argument is that we should change the test. I mean, you can make that argument that we should change the test, but what's the relevance of the second test if the police officer can only look at exactly what Mr. Chase looked at under the private search doctrine?
Yes, Your Honor. The relevance of that second one is because the first search is done by the private searcher, but in a majority of circumstances, that second follow-up search is actually executed by the police themselves. And so we need them to be virtually certain when they are conducting that follow-up search that they are accurately replicating that search, because they may not always have all the facts available to them about what exactly the private searcher
But
did.
that's not what the test says. In United States versus Jacobson, we held that there's a virtual certainty that nothing else of significance could be revealed through its actions.
Yes, Your Honor. Based on the facts of Jacobson, because the private searchers had gone through the entirety of the package, he could be virtually certain that he was replicating that search and wouldn't find anything new. There was no potential based on the facts specific to Jacobson because of how thorough the private search had been of that package, that anything else could possibly be revealed.
But then how does the private search doctrine work with the issue of consent? Because clearly here, Mr. Chase had the ability to access the computer. There's no allegation that he did anything illegal or improper in opening the computer. He didn't hack into the computer. It wasn't password protected or anything along those lines. He just opened it. He had access to it. He had the ability to view the files. So under the consent doctrine, the search was legal. Okay. And I know we're not talking about consent here, but doesn't your argument conflate the two doctrines, the private search doctrine with consent? In other words, the private search doctrine is meaningless. It doesn't mean anything at all. We just get rid of it under your interpretation.
Well, Your Honor, it's important to note that the consent doctrine, it would have some bearing on who actually owned the laptop, understanding that this is ultimately Ms. Gates' laptop. But crucially with the consent doctrine, you're not dealing with affirmative actions taken by the private searcher. And the private search doctrine is concerned with the actions taken by the private searcher. And so its scope is more clearly defined. With the consent doctrine, if consent is acquired, there is no concern about the exact actions taken so long as you're within the scope of the verbal assent. There's a difference between the words and the actions here. And furthermore, the private search doctrine doesn't actually require consent of the person whose information is being searched. And one of the things that Jacobson talks about is the concerns of co-conspirators revealing information to you that revealing information to police that the defendant was not intending to be shared. Ultimately, it's not so much concerned with consent as it is with the actual actions taken by the defendant, by the private searcher. This is consistent with the vast majority of circuits who have dealt with this issue in the modern age. Following Riley versus California, the First Circuit in the United States versus Riviera Morales, the Sixth Circuit in the United States versus Lichtenberger, the 10th Circuit in the United States versus Sparks, the Ninth Circuit in the United States versus Wilson, and the 10th Circuit in the United States versus Ackerman have all agreed that the proper way to limit the private search doctrine in the digital age is to the specific information viewed by the private searcher. Because as Riley explained, there is a tremendous amount of information at stake in these digital searches. Riley made clear that a computer or a phone in that case, and certainly a computer.
Mr. Miller, if that's the case, how do you then distinguish the Runyon opinion in which the private search had not been through the entirety of a CD, but nonetheless was held to be appropriate?
Your Honor, Runyon was decided in 2001 and was dealing specifically with floppy disks. And that's an important distinction from where we find ourselves today. A floppy disk is a very different risk to privacy than a laptop computer is. It doesn't contain the same amount of information, doesn't present the same privacy risks. And to the extent you find them similar, Your Honor, frankly, we find Runyon to be wrongly decided. And that's been recognized by a number of circuits, including the Ninth Circuit. I'm out of time for that reason, Your Honor. We ask that you reverse the 14th Circuit. Thank you.
Hey, Mr. Vestag. Mr. Coxon. You can proceed when you're ready.
Thank you. Good evening, Your Honors, and may it please the court. My name is Wayne Tuckson, and I am representing the people of the United States of America. The case before us is about one thing: maintaining investigative efficiency within the modern world. The 14th Circuit was correct in affirming the district court's ruling denying Ms. Gates' motion to suppress all evidence obtained from Ms. Gates' laptop. Specifically, that A, the collection of evidence fell under the scope of the private search doctrine as established in U.S. v. Jacobson, thus establishing the search as constitutional under the Fourth Amendment. And that B, the container rule created by Jacobson and further defined by the Fifth Circuit in Runyon appropriately frames the limitations of law enforcement. And that in this case, Detective Jenkins acted within that framework. In respect to the first issue, the search conducted by law enforcement was not in violation of the Fourth Amendment because the search was originally initiated by Mr. Chase, a private individual. As expressed by Jacobson, the Supreme Court ruled that the Fourth Amendment only prescribes to governmental action and that a search first performed by an individual, even if it's an unreasonable one, without the influence of a government official, does not fall under the Fourth Amendment. Specifically, in this case, Mr. Chase's initial search and discovery of the incriminating evidence started as a search based on the fear that Ms. Gates was having an affair. It was not until he discovered the incriminating evidence that he invited the police to come replicate the search. This demonstrates Mr. Chase's lack of expectation of privacy. It would be overly unreasonable to handcuff law enforcement from carrying out searches in a situation where they had been invited by a private searcher who had already found the compromising evidence. Additionally, the Supreme Court in Jacobs created a container rule, which allows for law enforcement to replicate a private search within a closed container.
So when we're talking about a container though, Mr. Tuckson, when you're looking at a laptop, is it the government's position that the container is the laptop? Is it a folder? Is it a file within a folder? What's the container?
No, Your Honor, the container would fall under as a file. And this would be demonstrated as in Runyon. While Runyon did take place in 2001 with a tangible piece of evidence being a computer disk, it's still a file, a computer file that has multiple access points within it. In this case, the holiday photos file and the subfolders connected with Halloween event and Halloween hijinks, the holiday photos file acts as the container.
So then what about the fact that he was led to this Halloween hijinks folder because he had run this properties function? Is that a separate search?
Well, Your Honor, the search originally followed by the replicating Mr. Chase's search that Mr. Chase gave direction to Detective Jenkins was the original private search. Then Detective Jenkins expanded that search to the Halloween hijinks folder after following directions where he saw under holiday photos, the Halloween events and Halloween hijinks. Mr. Chase led him to the Halloween events folder. Detective Jenkins asked if there was any other photos within that folder, within that subfolder. Detective Jenkins then, using the substantial certainty test, expanded that, which was underneath the container rule, as discussed in Jacobson and as expressed in the Fifth Circuit in Runyon, the Seventh Circuit in Atchison, and the Eighth Circuit in Bowman.
But when we look at that test, one of the things that we consider is the expertise of the officer, right? And here, Detective Jenkins was a homicide detective, right?
Yes.
And so he's ostensibly experienced in investigating homicides. I don't know that necessarily leads to him being experienced in how computers work, how people set up files, when they set up files, how to run the property function. So when we're looking at his expertise, where does he have expertise in that?
Yes, Your Honor. Well, he has over 15 years of investigative experience. And while that is in homicide, investigative experience could lead, and homicides do have digital evidence that comes up in multiple occasions. His investigative experience can be applied broadly over to any aspect where that may lead him. And in fact, as this is demonstrated by the fact that he controlled for a folder that was similarly titled and created on a similar date as the other folder. He was also aware that Miss Gates was at the party, was the photographer of the party in understood and was substantially certain that being the photographer, having an organized folding system that he controlled for, he would find other evidence relating to the crime that happened that night. And speaking to the three-factor test, Detective Jenkins falls right underneath the three-factor test that was created in Runyon, where he followed the statement of the private searcher, which was Mr. Chase, when Mr. Chase called him. And then the second, his replication of the private search led him to see the titles of the subfolders when he entered the container file of holiday folders.
Mr. Tuxson, would you have a problem if the officer had found pictures of child pornography in the Halloween hijinks folder?
No, Your Honor, I believe.
Argument would be the same.
Yes, Your Honor.
Well, then how can you make the argument that viewed objectively, the officer would have been substantially certain that there was virtually nothing else of significance that could have been revealed? Child pornography would have been extraordinarily significant. It's contraband, and we would be probably talking about a sentence on possession of child pornography, not kidnapping.
Yes, Your Honor.
So under your version of the test, the virtually certainty or virtual certainty or substantially certainty means nothing.
The substantial certainty under the three-factor test in Runyon means that Detective Jenkins was substantially certain that because of all the factors, which is using as the fact that Miss Gates was the photographer, the fact that the folder was entitled Halloween Hijinks when the event of the crime took place on Halloween, and that Detective Jenkins knew that Miss Gates had been there and seen the evidence, that substantial certainty leads him to believe that there was more evidence from that night.
But isn't that the problem? The more evidence, isn't that the problem for you? I think he has to be substantially certain that it's not going to lead to evidence of another crime.
Yes, Your Honor, correct. It has to be specifically relating to that event.
But here, how could he have been substantially certain that if he looked in the Halloween hijinks folder, he would not have found possession of child pornography? I understand they were created at the same time, but you've got a Halloween event folder and you've got a Halloween hijinks. I have no idea what Halloween hijinks means, by the way. I don't have a clue, as I sit here. And I don't think he did either. And that's the question that I have. How does he know that when he opens that file, it's not going to lead to evidence of another crime? It could be pictures of her smoking crack cocaine or doing meth.
Yes, Your Honor. Well, then that possibility exists, but he would be substantially certain that, yes, because it was a summer time and Halloween hijinks, even speaking to the nature of the frivolity that happens on that evening, he was certain that there would be more evidence in there due to multiple factors. It's not just one factor of being similarly dated. It's not just another factor of being similarly titled. It is an amalgamation of all the factors being dated, titled, what she was doing at the party. The fact that the original piece of evidence found was her wearing the sash.
Why wouldn't it be much simpler for law enforcement if we were drawing a line for law enforcement so police officers knew exactly what they could do and couldn't do if we didn't adopt the test that Mr. Miller proposed? That if an individual, in this case, Mr. Chase, looked at a particular file, the police officer can look at that file or that photo or the thumbnail pictures, and that's it. And at that point, if the police officer has evidence that a crime is committed, the police officer should get a search warrant. That's the end of it. It's the end of the analysis. Why shouldn't we draw the line right there?
Because one, Your Honor, we do not want to handicap law enforcement when they're doing their investigative
We're not telling
ability.
them they can't go get a search warrant.
Yes, sir. But with the time it takes to get a warrant, there is possibilities, especially in this digital age and on a laptop, that evidence could have been destroyed. It could be destroyed remotely with the new capabilities that are around in technology. It could have allowed Ms. Gates opportunity to come back. A multitude of circumstances could happen where that evidence would have been destroyed. And
But that happens all the time, Mr. Tuxson, right? That there's always the possibility that evidence can get destroyed or that people can take off. You know, that's a given. And here, given what he saw, that he saw the photo with the sash, the same sash that was left behind, that it was on the same night, there's your probable cause. And you could, easily, if he knew that this was his break, we've got telephones these days. can call a judge, explain what's happening. And it's not that it's going to take you, 3 days to get a warrant. You can get a warrant and he could stay right there with a computer. So I'm not sure what the problem is or what the issue is in terms of getting a warrant. Like that should be the default, right?
Well, Your Honor, in this circumstance, Detective Jenkins did not need to get one because of his substantial certainty of what he would find in that folder. And that was what he was relying upon, his investigative expertise. The time it took to get the warrant was over an hour, and that still did allow opportunities for.
Was there any evidence in this case of exigent circumstances?
Being the fact, Your Honor, that this was the Bill of Rights does bring a substantial circumstance to why the government would be interested in not having any evidence to shore them.
We're not talking about a car or something like that they could just drive away, right? Our exigent circumstances doctrines is pretty specific as to when a police officer can search based on exigent circumstances. Is there any evidence here that there was exigent circumstances that would preclude the officer from getting a warrant?
Your Honor, understanding where the document was located was if it was Miss Gates' actual storage unit that was separate away from the house was one circumstance for understanding where that was located. But as far as that being understanding, it could still have been moved because it was not actually on the on-site location of where Mr. Chase and Detective Jenkins were at the time. Additionally, evidence in the modern world is becoming more and more digitized. Personalized documents and photographs are rarely printed, and limiting the container rule to only printable, tangible material would significantly harm law enforcement's ability to effectively do their job. As far as the riot test, which calls for virtual certainty and a higher privacy concern with electronic devices, that is overly narrow. While a laptop does have vast amounts of data spanning over large amounts of time, Detective Jenkins controlled for that aspect by specifically searching for files within a similar data and corresponding title. The virtually certainty test is overly narrow, but it is still likely that Detective Jenkins' actions would have satisfied underneath that. By identifying the file, by identifying that Ms. Gates was at the party, by understanding her job at the party, Detective Jenkins would have had more information than necessary to understand his virtual certainty. Looking at Walter in the United States and understanding too that most Fourth Amendment violations that came from expanded private citizen search, expanded private citizen searches by law enforcement were ruled as Fourth Amendment violations due to bringing in extra technology that was more intrusive and more extensive than what the private citizen search had. In the case of Walter v. United States, the Supreme Court decided was when law enforcement, when the private citizen search originally got film in of obscene material, used the old school film to look into the light and see the pictures of the obscene material on the film. When police came, they took the film and put it into a projector. Having that extra technology established a more intrusive and more extensive search than what the private citizen had available.
Mr. Tuckson, if the police officer had looked in a different folder that was titled, let's say, Bill of Rights, not subfolder, but a different folder that Mr. Chase had not looked at, would you have a problem under your private search doctrine?
Yes, Your Honor, that would have been outside the scope. The container in this sense was the holiday photos. The subfolders underneath the container were accessed by Mr. Chase. Mr. Chase directed Detective Jenkins to look into the holiday photos folder and then saw these subfolders following his instructions. Then he controlled a search within that original container, which led him to the Halloween hijinks folder, where he did see the Bill of Rights sitting in Ms. Gates' storage locker.
That test, isn't the container just whatever you say it is?
No, Your Honor, the container is established because of, and this is looking as in Runyon, when you see one file on the computer disk, the law enforcement has access to all the files that are on the computer disk. In this case, the holiday photos acts just like the CD disk. Extending this search past the holiday photos, say to all the documents that are on the computer or all the photos on the computer, would be massively unreasonable and would be too far of a reach from law enforcement.
Why shouldn't we?
The history, right, of searches.
If,
So, if you were to look at her search history and see how when is the Bill of Rights coming to my town? Right? That, would that have gone beyond what was appropriate?
Your Honor, my time is up. May I please? Looking at the search history would go beyond, especially we would be concerned at looking at a collection of data to see an individual's entire history, their movement, what they have been looking at, what they have been doing. That is a massively unreasonable search. In this case, this was a search that was based off of substantial certainty because the photos file acted as the container, and the Halloween hijinks that was a subfolder with Halloween event was within the container, and Detective Jenkins was within his rights to look at that. We ask that you uphold the 14th Circuit's holding. Thank you very much.
Thank you, Mr. Tuckson. We'll now hear from, are you rebuttal first, Mr. Miller?
Yes.
Rebuttal. How long do you have for rebuttal?
2 minutes, Your Honor.
Whenever you're ready, you can proceed.
Your Honors, the government contends that this case is about maintaining efficient investigations in the modern world. But as Justice Ellis pointed out, the modern world has made it easier for the government to get a warrant. Under Federal Rule of Criminal Procedure 41D3, a police officer can make a telephone call to a judge and get a warrant. If the police are so substantially certain, or so virtually certain, that they are correct in what they'll find, certainly it is no great barrier to their investigation to require them to call a judge as a neutral outside arbiter to confirm.
But that means the document or the doctrine is meaningless.
Your Honor, the doctrine allows for him to go in and view that initial folder to see the misdemeanor sash. That misdemeanor sash does not require a warrant to view, and that gives him probable cause.
But if a police officer walked into a room and there were 12 identical packages on a table, and each one was identically wrapped in brown paper bag and then cellophane, and an individual in the room said, I opened one package and I called you because the package is full of cocaine. It's full of cocaine. And there are 11 identical packages sitting right next to it. Would the police officer have the authority under the private search doctrine to cut into the 11 other packages without a warrant to determine whether or not they contained cocaine?
No, Your Honor. They would be able to look at that first one that the private searcher looked at, and using that, because we do have concerns about what witnesses say. When we're asking a judge for probable cause warrant, we are concerned about the accuracy of the information that we're providing them. This allows the police to verify the accuracy of that information, make a 5-10 minute phone call, and get the warrant to confirm that they are correct. And furthermore, to the extent that the government is worried about evidence being destroyed, under United States versus Place, this court has held that you're allowed to seize evidence if you have probable cause and concerned about its ability to be destroyed. They could have seized the laptop in this case to prevent that. I thank you for your time and ask that you reverse the 14th Circuit. Thank you.
Okay, thank you, Mr. Miller. Okay, now Mr. Vestag, right?
Yes, Your Honor.
Okay, and we turn to our sentencing issue on the guideline section 2B 3.1. You may proceed whenever you're ready.
Mr. Chief Justice, and may it please the court. My name is John Vastag, here on behalf of the petitioner Bethany Gates. This court has repeatedly recognized that the federal sentencing guidelines are designed to provide honesty, consistency, and proportionality in criminal sentencing. But the 14th Circuit's broad and unwieldy approach to the abduction enhancement in the robbery guideline doesn't pursue these interests, and in fact, it harms them. This court should instead adopt a narrow approach, where abduction occurs when a victim is removed from the building in which they are found. This is for two reasons.
Mr. Vastag, I'm sorry.
Go ahead. Go ahead.
Yes, sir.
Vastag, why don't we just employ a plain language approach to this guideline? Words are known by the company that they keep. And this particular guideline, of course, refers to moving someone, accompanying someone with force from or to a different location. Why is that phrase not simply plain? Why is that a plain meaning? Why wasn't the 14th Circuit wrong in assuming that there were multiple meanings there? And in other words, that different location is surrounded by a purpose, by other words. That is to either effectuate the offense or to effectuate an escape. And thus, why doesn't that phrase answer all questions?
Precisely because, Your Honor, different location can be taken at many different levels of generality. But
And
what we're
hence my problem. It's completely arbitrary. Whether we say it's a different room, whether we say it's a different building, whether we say it's a different street, a different state, a different country, the earth itself, it's completely arbitrary. Why not just employ the plain meaning of those words, that it is a different location, but frame them in a way that is in reference to the purpose that's built within the guideline? That is, was it moved into a different location for the purpose of effectuating the offense and or escape?
A few things, Your Honor. First, the facilitation of the offense or for escape, that's not going to different location. Different location is a separate element altogether. And the reason that we shouldn't just take the plain meaning is because the plain meaning is not immediately obvious. That's why this is an interesting case. As Frank Easterbrook wrote in 1994, it's very hard to use plain meaning in interesting cases because they aren't immediately obvious. But this is not a linguistic exercise. This is interpretation of the sentencing guidelines, which are designed to provide consistency. And so this court should.
That plain language gives us that consistency, does it not? I mean, suppose, for instance, let me provide a hypothetical that you perhaps will assume is clearly not abduction, though I'm not sure I would agree. Suppose that there was a treasure chest full of gold and someone wanted to steal it. And there was a person sitting on the door of that treasure chest, and someone physically, forcibly, against their will, moved that individual off that chest of gold in order to thieve it. Why is that not plainly moving someone to a different location for the purpose of effectuating the offense and thus abduction?
Because that does not fit within the example that is given in the commentary to the sentencing
I
guide.
don't care about the commentary because I don't need to go there. In other words, if the language is plain, I don't need to go to the commentary of the guideline. I just follow the guideline.
But Your Honor, for the purposes of the sentencing guidelines, the language is not plain. If we could simply tell district judges to apply it in its plain meaning and expect them to always come to the same conclusion when the fact patterns are the same, then we wouldn't need the sentencing guidelines. But these are designed to provide consistency. And it is a reality that if we tell district judges to apply it in its plain meaning, they're going to come to different outcomes. And we should instead be encouraging consistency within our sentencing. And that's why the narrow approach pursues that. Provides a, Your Honor.
I don't always pretend to know what district judges think, but I would dare say that they would find it a breath of fresh air to say, apply the plain meaning of the guideline.
I imagine district judges would love to be able to use that their discretion in that way, but district judges also want to be confident that they're applying the law correctly. They want to be confident that they're accomplishing justice. And the best way for them to be confident they're applying the law correctly is to provide them with a bright line rule, to provide them with the narrow approach, which says that you don't remove the person from the building, then it's not abduction. And this is important.
I guess, Mr. Vastag, though, that I can imagine where something would be abduction if they're within the same building, right? Where I've got somebody by the front door, and now I have taken that person and locked that person, say in a bank robbery. I have taken the teller from the front door to the back, and now we're in the vault, right? And I've locked the two of us now back into the vault. We're in the same building, but the teller can't leave. And I have taken the teller from one location by the front door all the way in the back to the vault in order to enable me to rob the bank, right? Don't you think that really it's the purpose of the defendant's actions that the district court needs to look at as to whether this action is more serious or less serious, and then requires these enhancements that might attach, as opposed to saying it's a building or not a building?
Not at this stage in the sentencing guidelines. Here, we are applying specific offense characteristics to the enhancements, and that's meant to be a mechanical process. And in the hypothetical that you offered, that fits much better within the physical restraint enhancement that's in the same subsection of the guidelines. And that's defined as a person being physically restrained, such as being tied up, bound, or locked up. And in your hypothetical of being taken to the vault and locked up, that fits nicely within the physical restraint enhancement. But the dangers that victim is presented with increases if they are taken away from the building. The space outside of the building is orders of magnitude larger than the space within. And so,
But is it more dangerous if I take the teller in this instance, in this example, I take the teller into the parking lot, as opposed to I take the teller and I lock the two of us in a vault?
in the context of abduction, yes, Your Honor, because the main concern with abduction is the taking away of the individual. That's why one of the elements here is taking them to a different location. In the context of abduction, once you leave the bounded area of the building, the dangers only increase because now the area in which we have to search for the victim is significantly larger. The chances of being rescued are significantly lower. And so this enhancement is designed to punish conduct that creates those kinds of dangers. And here we should take the narrow approach because
where do you find that purpose stated within the guideline itself? Where is that purpose stated in the plain language of the guideline?
it's not stated in the plain language of the guideline.
You're
Your Honor.
reading that into it.
Yes, Your Honor.
Why should we read that into it?
Because as with all statutes, we have to divine meaning by what it's accompanied with. And if we look at the definition of abduction found in the application notes of the sentencing guidelines, we find that they give the example of taking a bank teller from the bank to a getaway car. Now that treats the bank as a particular location and the getaway car, a place outside of the bank, as a second location. And that's very illustrative. If the sentencing guidelines were intended to allow for simple movement within a building to count as abduction, then the commission chose a very strange example because leaving the bank to a getaway car would be a very intense and dangerous part of abduction rather than the mine run case.
Well, it seems to me that different location is limited by the phrase to facilitate commission of the offense or to facilitate its escape. Would you agree with that?
I would not, Your Honor. I believe that different locations, when we talk about facilitation, we're referring to the actions of the perpetrator. We're referring to why are they moving them? If they're moving them to facilitate the offense or their own escape, then it falls underneath the definition. But when it comes to a different location, that refers to where they move them. And so I don't think that actually bears in the construction of different location.
But if that was the case, if we were to read it that way, location could mean 5 feet away. So if you took someone into your custody on the left side of the room and you moved them to the right side of the room, you could conceivably change their location. Right? They moved from the left side of the room to the right side of the room. But if it had nothing to do with facilitate the commission of the offense, then it wouldn't be a 4-level enhancement under the abduction statute, right?
Correct, Your Honor. If the action that the defendant was taking was not intended to facilitate the offense or escape, then it would not fall under this definition.
But if they moved them from the front door of the bank and locked them into the vault so they could proceed with the bank robbery, wouldn't they be moving them to a different location in order to facilitate the commission of the crime?
Under the broad approach, perhaps, but the broad approach suffers from a lack of specificity.
Why wouldn't, if Congress, or in this case, the Sentencing Commission, wanted it to be a different building, why didn't they just say so? Why doesn't it read, a victim is forced to accompany an offender to a different building?
Because the victim might not be moved to a different building and a robbery could still occur outside. But here in this context, when a victim is found within a building, it's proper for this court to do some reasonable line drawing to give district courts a clear, bright line and consistent rule.
What is that bright line?
Go ahead.
What's the bright line?
When a victim is removed from the building in which they are found, then that constitutes an abduction, and so long as it meets the other elements of the offense.
What if it's a 48-story building and they go from the 48th store into the basement of the building, into the cellar where nobody ever goes, into the boiler room? Is that a different location?
No, Your Honor.
Right. What if they walk from the front door of the bank right out onto the steps of the bank? Is that a different location?
Yes, Your Honor. And here's
How
why.
do we make sense of that?
Because when you remove the victim from the building, you remove them from a bounded area and the dangers associated with abduction increase. The area outside of the building is significantly larger than the area inside. And as long as the victim remains inside that area, then the dangers that they are presented with are not as strong. And thus the enhancement should not apply with as strong.
A lot of
So-
bad stuff could go on in the boiler room and probably less so on the front steps of the bank.
Yes, Your Honor, a lot of bad things could happen. And if a district court is concerned about their ability to accurately reflect the offense in the sentencing, then they have the ability to use their discretion to do that, but not at the stage of specific offense characteristics, which should be a mechanical process. Instead, they have discretion in terms of variances and departures if they feel that the terms of the offense are not adequately represented by the sentence. And so if those bad things happen, then district courts can do something about it. But the sentencing guidelines are designed to provide consistency. They're not designed to provide.
I'm sorry to interrupt you again, Mr. Vesteg, but to your very point, can't the district court do something about it in terms of finding that perhaps in a given case that though the abduction enhancement applies and plainly applies according to its clear language, that nonetheless, for whatever reasons under the sentencing factors that the court later considers, that it doesn't apply as much in force? Couldn't that argument that you just made be flipped on your position?
It could potentially, but the problem, Your Honor, I apologize. My time has expired. May
You
I
don't get
continue?
out of here that easy.
I defer to the Chief Justice.
So, I'm sorry, Your Honor, could you repeat your question?
Yes, I think your position is that the district court could address this under variances. You're referencing the 3553A factors, I believe. Why can't the district court address that even when the abduction enhancement applies according to its plain language? So if, for instance, in my scenario where someone is removed from the door of a treasure chest and slightly abducted to the side, though it be forcible and against that individual's will, why couldn't the district court merely address the measure of that abduction under the 3553A factors?
Because that would still leave us with the same problem that the broad approach presents, and that's a lack of consistency. It gives district judges too wide of discretion to apply the enhancement to specific fact patterns that may be similar, but different district judges will do different things. And for that reason, we encourage you to adopt the narrow approach, which provides district judges with a bright line rule that they can consistently apply. Thank you, Your Honors.
You're welcome. Okay, Mr. Witzak.
Mr. Chief Justice, and may it please the court. My name is John Witzak, and I represent the respondent, the United States of America. This case is about protecting and furthering a chief goal of the sentencing guidelines, giving defendants sentences that are proportional to the severity of their crimes. The record in this case makes it clear that the defendant did far more than merely physically restrain the victim. And in fact, her behavior represents the precise conduct that the sentencing guidelines sought to punish more severely through the application of the abduction enhancement. As such, this court should affirm the holding of the circuit court, which found that Bethany Gates did in fact move her victim to a different location and that the 4-point sentencing enhancement for abduction is appropriate. The circuit court's reasoning is the best method by which to differentiate between physical restraint and abduction, because it allows district courts to use their expertise, discretion, and intimate knowledge of the case of the facts to tailor a sentence that is fair and in line with the policy of the sentencing guidelines. In rejecting a mechanically based approach that looks merely to the presence or absence of lot lines, doorways, and other thresholds, the circuit court rightly focused on the harm to victims rather than the physical characteristics of the crime scene.
And here, though, Mr. Witzek, isn't it clear that what she was doing was really restraining him, right? She didn't want him to get away. right?
Your Honor, it is clear that she started out by restraining him. There's no doubt that her first actions, which were brandishing the knife and tying his hands behind his back with the red sash, do constitute a physical restraint. But those actions were just the first steps of an increasingly severe sequence of criminal conduct. And briefly going through the facts, I think, helps demonstrate the two different scenarios that played out here. First, it was a physical restraint, but by her actions, she increased the situation to one of abduction. So after brandishing that knife and tying his hands behind his back, Gates then moved Greenwood a total distance of 50 feet. She started off by taking Greenwood through an archway of the museum that the museum staff had clearly marked off with the 2 brass stanchions and a velvet rope. She then moved him further into a still under construction exhibit room toward an empty inset wall display and pulled back a heavy red curtain that was placed there to keep the display out of the eyesight of visitors. Lastly, she put Greenwood into that display alcove. This sequence, the entirety of which took place after that initial physical restraint had occurred, forced the victim into a plainly separate and unique area of the building. It isolated him with a knife-wielding criminal, and it ensured that his whereabouts would be known by nobody else but Gates herself. To find that Gates merely physically restrained her victim would essentially mean that this sequence never happened.
Mr. Witzek, can you provide me an example of a case where someone was physically restrained, but the abduction enhancement did not apply under your test?
Where someone was physically restrained, but
the abduction enhancement did not apply.
Yes, Your Honor. So there are the 6th, 7th, and 11th circuits have a more narrow interpretation than the government is advocating for. And they followed the petitioner's view that one, generally speaking, has to leave a building. So for instance, in Hill, the 6th circuit found no.
I understand. I'm talking about in the test that you're advocating. Can you give me an example of a hypothetical example of where the physical restraint guideline enhancement would apply, but the abduction enhancement would not?
Absolutely. So just applying the facts of this case, if Gates had merely tied Greenwood's hands behind his back and then left him in that initial room where the Bill of Rights was to be displayed, that would merely be a physical restraint.
But why that room? What if she moved him from one side of the room to the other?
So the 3 factors that the government advocates this court look to are moving a victim to a discrete and separate location, which will isolate the victim with that criminal and create uncertainty as to that victim's whereabouts. So I think it would be unfair, Your Honor, to a defendant to say that they abducted someone when they merely just tied them up and left them in the same room, because we have to look at abduction and physical restraint in the context that they are written in. And they're right there in the guidelines right next to each other. So it would be a bit of a stretch to say that physically restraining someone and then moving them 5 feet is an abduction. Whereas.
Well, why is the government advocating for these other factors, which appear nowhere in, well, except for maybe one, otherwise appear nowhere within the guideline? Let me go back to the question I asked your counterpart. Why again don't we answer all questions with respect to the purpose within the guideline as it's written? That is, did the forcible movement effectuate the offense or escape? Why not leave it at that?
Because the plain meaning of the term different location is ambiguous. Different
concedes that point.
Yes, Your Honor. The different dictionary.
Take that away from me?
Sorry?
You're going to take the idea that I just advocated against your counterpart, that this is plain as day, away from me?
Your Honor, I think in all fairness to a defendant, I don't think that a 3 feet movement would qualify for the 30-month enhancement between physical restraint and abduction.
Commission said.
Well,
they said it was a different location. Why is the government not arguing that this is plain as day? And if it's not plain as day, or if it should be written a different way, then the commission can rewrite it.
That is absolutely true, Your Honor. The commission can rewrite it, and the government contends that because the commission has not either issued a formal amendment or added to the commentary, that clearly demonstrates that this harm-based approach that the 1st, 4th, and now the 14th circuits have taken is well in line with the policy goals of the commission. But as far as looking into the intent of the sentencing guidelines, I think the example sheds a lot of light on this situation. And that is when a bank teller is moved from inside the bank to a nearby getaway car. So this obviously includes a clear measure of movement beyond.
But why isn't the test the language to facilitate commission of the offense? To facilitate commission of the offense has nothing to do with the definition of abduction. Okay, abduction says move to a different location. Why are they moved to a different location? in order to facilitate the commission of the offense. So if you move someone from one side of the room to the other in order to facilitate the commission of the offense, why should the 4-level enhancement apply? On the other hand, if you move someone from one building to another and it has nothing to do with facilitating the commission of the offense, it wouldn't apply. Why are we not focused on the phrase to facilitate the commission of the offense?
Because neither party here is arguing that either tying up Greenwood or moving him was not done to facilitate the commission of offense. The facts make it very clear that he was placed in that exhibit room for the purpose of allowing Gates to escape. But looking here, I think we do have to be fair to defendants and not apply an abduction enhancement merely for a minuscule amount of movement. Here, there was much more than a minuscule.
Doesn't the abduction enhancement serve an altogether different purpose than the physical restraint enhancement? Don't they serve fundamentally different purposes?
Yes, they do, Your Honor.
So why should we then be concerned about the level of enhancement that the commission has assigned to abduction? And again, to the extent I have, as a district court judge, to the extent a district court judge has a problem with that, that can be addressed, as your counterpart said, in a variance.
Sure. So the abduction enhancement seeks to redress potential harm that comes to a victim when they are isolated with the criminal and when their whereabouts are potentially unknown. These same concerns are not explicitly clear when there's merely a physical restraint. Here, however, those exact concerns manifested themselves in the fact pattern. Bruce Greenwood was taken off into a different area of the museum. Nobody knew where he was. In fact, most of the museum goers had thought that he had went home early because he had drank too much. And he had to spend 4 hours tied up and alone behind a heavy red velvet curtain in a very dangerous situation. The record makes it very clear that he was intoxicated and that he had actually passed out at the end of the night and the ambulance had to be called. None of those harms would have manifested had he only been physically restrained. Had he only been physically restrained, he would have been found 15 minutes after the robbery, because as soon as the museum staff went into the exhibit room to get the Bill of Rights, they would have found him, and he wouldn't have had to spend 4 hours tied up and alone. But the fact that he was moved past the 2 brass stanchions, past the archway, and past the heavy red velvet curtain show that he was moved into a different location. And the government is simply advocating for this court to recognize the fact that abduction and physical restraint seek to redress different crimes. They seek to give out sentences that are in proportion to the severity of a defendant's crimes.
Well, but in most cases, right, with abduction, it's that you are concerned about the victim spending time alone with the defendant, right? Here, she moved him essentially from the scene of the crime so that he'd get hidden, and she took off, right?
That's right.
And in the example that the Sentencing Commission uses in the commentary is that the bank robber takes the teller into the getaway car with the bank robber, right? And it's not leaving the teller locked in the vault behind while the bank robber gets away. But instead, it's this continued exposure to the danger after the commission of the offense, right?
Your Honor, I would disagree slightly with that. I think the Sentencing Commission's example very clearly shows that it is the potential harm that it seeks to measure out in the sentencing. So in the example, all that we know is that that bank teller went from the bank into the getaway car. We don't know how long that happened. We don't know if that getaway car actually took off. We don't know if the bank teller immediately was released from the getaway car. All we know is that the potential harm that comes from being isolated with a criminal, and which becomes from being potentially unknown, your whereabouts being unknown, is exactly what the Sentencing Commission sought to punish through the abduction enhancement. And that is exactly what happened here. Bruce Greenwood was left alone for 4 hours in an area where nobody else other than the criminal knew where he was. And as far as the petitioner's point about uniformity and consistency, it should be noted that while this is a central goal of the Sentencing Commission, it is not the only goal. The Sentencing Commission also looks to have fair sentences, uniformity, and proportionality. And the Sentencing Commission itself has made it clear that seeking only to achieve uniformity can actually destroy proportionality. And so in this case, anytime we are looking at the difference between a physical restraint and an abduction, the district court necessarily has to use its discretion, its expertise, and its knowledge of the facts. To simply hold that An abduction can only take place when one is moved from one building to another or moved out of a building. Just does not take into account the many different situations that can take place during a robbery. For instance, the victim here was moved 50 feet, but one can easily imagine a situation where in a downtown area of a city, one is moved less than 50 feet, but happens to be moved between two buildings. Under the petitioner's view, that would amount to an abduction.
The movement to a different location has to be forced, right?
Yes, Your Honor.
The curator here was drunk.
He was.
How do we know that he was forced from one location to another?
Because the defendant brandished a knife. That was the first thing she did. And then she tied his hands behind his back with the red sash. So there's no case law that I'm aware of that stands for the idea that if a victim happens to be intoxicated, that in some way alleviates the severity of the criminal's offense. But he was clearly forced. He could not use his arms. And it is true that his intoxication perhaps made him an easier target. But I don't think that's any reason to be easier or to not impose the proper sentencing guidelines on the criminal. And the intoxication actually helps to prove the fact that, or the idea that Gates put him at an increased risk of harm that was completely unreasonable and that could not have happened had he just been physically restrained. He was drunk enough to pass out later that evening, and he was so intoxicated that even 4 hours after the robbery, he was unable to give a useful description to the police. Anything could have happened in that 4 hours when he was tied up behind that heavy red velvet curtain. He could have had some sort of reaction to whatever intoxicants were in his system. He could have needed help. Had he needed,
But what if she found him behind the curtain? Right?
What if-
So let's say the Bill of Rights was not on display, but in a staging area, right? And so she finds him in the staging area and ties him up, and he's behind this curtain and he's drunk. But she leaves, steals the Bill of Rights and leaves him there. And nobody knows that he's in the staging area. Nobody knows where he is, and he's there for 4 hours, right? Lots of things could happen because nobody knows where he is, right? So I don't know that that is necessarily a factor in terms of whether the abduction enhancement applies.
Well, the key difference there, Your Honor, is the forcible movement to the new location. If Gates had merely found him behind that curtain, then this would only be a physical restraint. If she had only found him and then tied him up there, that would be a physical restraint. But in that situation, Greenwood was responsible for the fact that no one knew where he was, because under your hypothetical, he moved himself behind that velvet red curtain. But here, everyone knew where Greenwood was. He was the museum curator. He was in the Bill of Rights room preparing for the biggest night of the museum's history. The only reason that none of the museum goers knew where he was because Gates forcibly moved him to a new location. And that makes all the difference here. He had to spend 4 hours alone behind that curtain, all because of what Gates did. And it's important to remember that the physical restraint was the first thing Gates did. That was brandishing the knife, and that was tying his hands behind his back. But the 5 steps that took place after that, that was the abduction, and that was the movement to a different location. Your Honor, the government asked that this court uphold the finding of the circuit court and apply the 4-point sentencing enhancement for abduction. Thank you.
Thank you, counsel. Mr. Vestag, rebuttal.
Your Honors, I have 2 minutes and 2 points to make. First, as you heard my friend on the other side concede, the language here is ambiguous. And in order to combat that
Why
ambiguity,
is it ambiguous? I just don't understand. Why is it not just modified by to facilitate the commission of the offense? Why should we not just read this? If the victim is moved from point A to point B, no matter what point A and point B are, it doesn't matter if it's 10 feet or if it's 100 miles. As long as the victim is moved from point A to point B, a different location, in order to facilitate the commission of the offense, the enhancement applies. In other words, if the defendant is moved from here to Houston, Texas, for a purpose other than facilitating the commission of the offense, the enhancement doesn't apply. But if the person is moved from here out into the hallway in order to facilitate the commission of the offense, the enhancement applies. Why is that not the test?
because that would not fit within this court's precedent when it comes to similarly worded
But
statutes.
wait a minute. But we don't, okay, so you're ordering stare decisis, then that's totally different. We can change the test.
Yes, Your Honor, but in order to use that as the standard would then make it so that it's nearly impossible for a person to can use any degree of force upon one of their victims and it not then become abduction. Because if they're trying to move,
That's the way it's written. That's a policy argument that you should take up with the sentencing commissioner, with the Congress, but not with us.
but Your Honor, then that would have a 4-level and very significant enhancement applied to almost all robbery cases. And the point of applying specific offense characteristics is to pursue that proportionality interest that might
Those are policy arguments. There are all kinds of provisions within the guidelines that I may or may not agree with, but I have to apply them because Congress told us to.
And Your Honor, they should be applied in context of the policy that the sentencing guidelines are designed to further. And that is consistency in sentencing, not a flexible approach that different district judges. Your Honor,
My approach is very consistent though, because it's location A to location B for the purpose of facilitating the commission of the offense. What's wrong with that?
because Your Honor, my time has expired. May
Go
I
ahead.
answer your question? Because different district judges can take into account what is considered sufficient movement, even moving the victim's feet, them moving back and forth. That could be moving them out of position. And perhaps they feel that that's in furtherance of the commission of the offense. By requiring a bright line rule here, such as under the narrow approach, we make sure that we only target that conduct that represents the significant dangers that a 4-level enhancement like abduction is meant to target.
Why
Thank you,
don't you,
Your
why
Honor.
don't you go ahead and make your second point?
Thank you, Your Honor. My second point is that, as my friend on the other side described, proportionality is an interest here, but we do not destroy one interest in furtherance of the other. And applying the broad approach here would instead give district judges wide latitude to provide varying sentences, even in similar fact patterns. And that destroys the consistency interest, which we should be pursuing and balancing against proportionality, which can already be pursued through departures and variances. Thank you, Your Honor.
Thank you. Okay, the court will take a brief recess.
Rise.
Thank you. You can all be seated. Okay, well, we're going to give you all some feedback, and we'll start with Judge Leichty.
Well, it was a real privilege to be here tonight, and let me kind of commend all four of you for the performance, the advocacy that we saw this evening. I was very impressed by how poised you each were, often under some intense questioning. Of course, you've seen that along the journey here leading to the finals this evening, but of course, each stage along the way probably ratchets it up just a little bit more, and you perhaps felt that this evening. But I was very impressed by your poise and your ability to think creatively, to pivot at times, and to think anew about these facts and the law that you've lived with for so long. Sometimes after you've argued this for such a long time, you become wedded to a view. And I saw at certain times each one of you pause and think anew, and that's a mark of a good advocate. More than anything, I was very impressed by how trustworthy you were. We've never met, and yet you were able to create instant rapport, at least with me, and I believe the other judges. And I felt that I could rely on what you were saying about the facts, about the law. And that's a very important relationship to create with a panel of judges or a judge, to create that relationship of trust and candor, because then cogency, advocacy can take on new forms, right? That's when you can really be persuasive. And I felt that, I saw that in all four of you. So I want to commend you all for the performance this evening, and I'll leave my comments at that. But congratulations to all four of you.
Judge Ellis.
All right. So I also, I'm short. I can't see anything. It's the bane of my existence. You should see my chair on the bench. It's like all the way up. I agree. The four of you did a fantastic job. And I can tell that you prepared very well. It's not easy to get here. You did things like you handled your nerves. I didn't see anybody shaking. Again, I'm short, maybe I missed it. But, you handled it well. You made excellent eye contact. You were very passionate about your positions, but also willing to give where you needed to give. And I thought that was very important. You knew the facts inside and out and were able to point us to the facts where it helped you and be able to distinguish facts when you needed to. And you knew the case law and you were able to point us to the case law and say, this is what other judges have thought about this particular issue or this particular question. Here's the analysis. Here's why you should apply it or why you shouldn't. So you all did really, really well. And I liked how you listened. Lawyers tend not to listen very well. But you listened and you picked up on what was important to each of us. And as you can tell, we each found different things that were important that would have gone into our decision-making process. And you picked up on that and then were able to identify what our concerns were and address those concerns directly. And as a judge, that's what we're looking for is if you listen, I will tell you what my problem is. And I will tell you where I am struggling with this issue. And if you can then address that, you are much more likely to persuade me than sticking with, this is my outline, here's my next point, I'm going to go to my next point. The judges will tell you, here's my problem, and I'm looking for you to help me solve it. And if you listen, you'll be a much stronger advocate for your client. So I think you all did a great job and congratulations in getting this far.
Yeah, I agree. I have very little to add. I thought you all did a terrific job. You all answered the questions that were asked, which is sometimes a very difficult thing to do. There's a judge who I sit with regularly in the Court of Appeals that has a very direct way of telling litigants oral advocacy and oral argument is the judge's time, not the lawyer's time. It's the time for the judge to ask questions and to help the lawyer or to help the judge understand the case. Everything you have to say to us should be in your briefs. And we've read your briefs. And in this case, we didn't get them. But we read your briefs. Our law clerks have prepared memos for us. We've analyzed the issues. We've thought about what our colleagues may think. And oftentimes on the Court of Appeals, at least we're asking questions for our colleagues' benefit as much as for the lawyer's benefit, particularly if we have an idea of how the case should come out. So answering, listening, and then answering the questions is very, very important. And it's very difficult to do, especially when you get up and you have certain points that you want to make and certain points you want to come across, and then the judge goes down a tangent. You were extremely well prepared. I thought extraordinarily well prepared, way better prepared than many of the lawyers we see in court on a regular basis. But you're going to get, when you're arguing cases, you're going to get issues that come up that you are unaware of or that you are unprepared for. There are cases we'll argue in the Court of Appeals, and the case will go to trial in the district court, and there'll be a 3-week trial and a couple on the Court of Appeals, and we'll have a question about jurisdiction that neither of the sides have thought about, or standing. And the whole argument may turn on jurisdiction. The whole case may turn on jurisdiction, and the lawyers will be totally unprepared for it. And they do the best that they can with what they have, but it's always better to be honest with the court. It very seldom benefits the court, whether it's district court, state Supreme Court, Court of Appeals. If a judge asks about a particular case and you're unfamiliar with the case, to try to fake it through the case, you may be hurting yourself by doing that. You're better off saying, Judge, I'm sorry, I'm unfamiliar with that case. And the judge will say, okay, and you just move on to something else. There's nothing the judge can do about it except say, okay. But I thought you were all extraordinarily well prepared and dealt with our questions very, very well. You were all extremely articulate, which is also important. You spoke in English words and we could understand. You spoke with a good cadence. You were loud. And that's very important. It's not always easy to do that. Words weren't muffled. I thought you were outstanding. I thought the case is an interesting case. All these cases are very interesting, and the problems are interesting problems. And this was no different, but I thought you handled it very well. So we have, this is very difficult. I actually like judging moot courts much better when you don't have to pick a winner or a loser. It's very, very, very hard to do. Okay. It's very hard to do because all four of you were outstanding. You wouldn't be here if you weren't as good as you were, but it's also a testament to the law school. The quality of the oral advocacy in a competition like this in the final round was very, very strong. And I'm sure that you defeated some very, very strong advocates to get here in what was 6 rounds. So this is round 7 for the 4 of you. So that's tremendous honor that you should be very proud of. So we selected as the 2 best oral advocates, Zion Miller and Wayne Tuckson. So So congratulations to the 2 of you, but congratulations to the 4 of you. It was not an easy decision. You were all really outstanding. So I have nothing else. I don't know if anybody else has anything or if we're done. Are we finished? Okay, great. Thank you, everyone. Appreciate it.